The Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you. This is the April session of the Middle Tennessee term for the Court of Criminal Appeals. On the panel today, to my right, our presiding judge, John Everett Williams from Carroll County, and to my left, Judge Camille McMullen from Shelby County. I am Kerwood Witt. I come from Monroe County. Arguments today will be 20 minutes aside. If the appellant wishes to reserve a portion of that time, the lawyer should request a reservation time at the beginning of the argument. Call the first case, please, or call the case, please.
State of Tennessee versus Vincent Parker Lee.
Thank you.
Good morning, Your Honors. May it please the court, Brennan Wingirter with the Appellate Division of the Public Defenders Conference here for Mr. Vincent Lee. Judge Witt, may I reserve 4 minutes for rebuttal, please?
All right.
Thank you. Your Honors, the doctrine of election of offenses requires the state to specify for the jury which evidence it is relying upon when it seeks convictions for each count in an indictment. This ensures that the jury deliberates upon the same evidence and returns unanimous verdicts regarding the evidence for each count. That did not happen in this case. The state has conceded that it failed to elect offenses at Mr. Lee's trial. The issue for this court is whether that non-structural constitutional error requires reversal or may be deemed harmless beyond a reasonable doubt. Before I get into the argument on the election issue, I do want to acknowledge we raised several other issues in the brief, and I'm happy to answer any questions the court may have on those. But I do think that the election issue is the most confusing, the most complicated, and unless the court directs otherwise, I plan to focus my time today on that issue. As I said, the state conceded it did not elect offenses at trial. This started out with a 10-count indictment, 5 counts of rape of a child, 5 counts of incest relating to 2 different victims. 4 of those 10 counts related to JM, the other 6 related to TM. After the state presented its case in chief and did not elect at that time, the defense moved for a judgment of acquittal, and the trial court granted that in part and ended up dismissing 4 of the counts from this 10-count indictment, all of those related to TM. So what went to the jury ultimately were 4 counts relating to JM and just 2 counts relating to TM. Of the 4 with JM, 2 counts rape of a child, 2 counts incest. Relating to TM, 1 count rape of a child, 1 count incest. Now, this court, in determining whether the state's failure to elect offenses from those remaining 6 counts, whether that is harmless beyond a reasonable doubt, requires the court to focus primarily on the prosecutor's closing argument. That's because the Tennessee Supreme Court has said that the election error, as it is a constitutional error, cannot be cured by the state's closing argument. But it might be deemed harmless if, beyond a reasonable doubt, this court can say that the prosecutor effectively clarified for the jury what proof, what evidence the state was relying upon for each count. In addition to closing arguments, the court may look to, of course, the proof that was presented. In this case, there was a video recorded interview between Mr. Lee and the detectives. Also, of course, the testimony from the witnesses at trial, and then any instructions that were given by the trial court. And I want to note before I get into what exactly happened at trial, trial was back in 2009. There's a significant delay between the time that the motion for new trial was originally filed and when that hearing on the motion and the new trial was eventually ruled upon. And so I think that we've had a significant development, although election is complicated no matter what. I think at least in the past more than 10 years, there's been some clarity provided to election. So I don't mean to fault any of the parties in this case for what happened back in 2009, when I think maybe the election doctrine was not as well understood by either the state. Yes, Your Honor.
a question or two. Do you agree or disagree that the election made during the state's closing argument was effective as an election?
Disagree, Your Honor. I don't think what the state did in closing can even be called an election. I think that it's an attempt at election, but I think that what happened during closing is not sufficient to clarify for the jury what happened, and that's because
now this attempt at election occurred during the opening closing argument, correct?
That's correct, Your Honor.
And typically that follows on the heels of the close of the evidence in the case, correct?
That's correct.
Well, how is it that there could be any prejudice between the time of the closing of the evidence and the time when this, as you say, attempt at election was made?
The prejudice, Your Honor, is not about the timing. It is about the fact that the prosecutor's attempt at election was legally ineffective. That's what our case law asked the court to look at. Was the state, what the state did in closing, was it a legally effective, it can't be a substitute for election, but was it a legally effective clarification for election? And that's our argument, that it did not do so in this case. There were 4 counts charged, and I want to be clear, I'm focusing on the counts against JM because there was only 1 count of rape of a child regarding TM. So I think that was pretty clear. The prosecutor didn't have to clarify for the jury what was going on with that 1 count. But
well,
for JM,
the jury would have had the same information if the same declaration had been made at the end of the proof as was made during the opening argument. There's no departure there from the information the jury received, right?
I disagree with that, Your Honor. And that's because the prosecutor's closing argument did not clarify, and at times was not consistent with the proof that came out at trial. So it's not really the timing here that we're worried about. It's the fact that of 4 counts relating to JM, the prosecutor told the jury, described for the jury 4 different allegations of sexual penetration that could have supported any one of those 4 counts, but repeatedly told the jury that's 2 counts. Within telling the jury that it was 2 counts, the prosecutor ignored the other 2 counts for incest, and then within those 2 counts, actually described 4 instances of alleged penetration. That's the confusion here, Your Honor, because we don't know what this jury selected as the basis of as the evidence that formed the basis for its convictions in counts 1, 2, 6, or 7.
So you're saying if the same election in the same terms had been made at the end of the evidence, it would have been flawed.
Yes, Your Honor, we'd have the same problem. That's exactly right. Because here, and I think I should probably get into what the prosecutor actually said versus what the proof at trial was. I'll say I have watched the video recorded interview several times. It's very confusing, but that's because it's a police interview. The testimony of the witnesses is confusing, but that's because they were children. It was the state's responsibility to clear that up. It was the prosecutor's responsibility to basically to put together from the evidence what it wanted the jury to find, specifically in counts 1, 2, 6, 7, actually 3 and 8 as well. And they did not do that. And so what we have is a confusing video back and forth where it's unclear at times whether the detectives are asking about JM or TM. Then during the testimony at trial, there was a point, it's a separate issue raised in our brief, but related. There's a point where the prosecutor is the one who interjects an allegation of penetration for the first time in one of the witnesses' testimony. And then in the closing argument, the prosecutor repeatedly goes back and forth between testimony and then trying to introduce or replay parts of the video recorded interview without connecting the statements made in both. And then goes on to describe additional acts of touching, which would not support rape of a child because there's not penetration. But then ultimately, by the end of closing argument, I tried to spell it out as clearly as possible because it's not clear in the brief, citing to pages where I could, where the prosecutor ultimately argues to the jury about 4 different allegations of penetration. We have 2 different acts allegedly occurring on February 11th. We have another act on an undated night in a different bedroom. And then we have the phrase sensation on all sides. And the prosecutor says that means he must have intruded. Those are the 4 allegations of penetration that the prosecutor argued both in opening closing argument and in the rebuttal closing argument, some combination thereof, though repeatedly telling the jury that's 2 counts. And so we see 2 issues with that, 2 problems with that. Number one, there's actually 4 allegations that the prosecutor is trying to fit into 2 counts. And then number 2, even if the prosecutor could have collapsed some of the acts, specifically the February 11th incident that the state on appeal is trying to make one incident, even though there were 2 different allegations made at trial, even if we can collapse those, which in our brief we've argued is not a proper way to elect offenses, we still have this separate allegation of the sensation on all sides phrase that, again, from the video, it is not clear what is being referenced at that point. But then in closing, the prosecutor appears to try to use that as, and again, it's unclear. I don't want to speculate whether the prosecutor is using that to try and bolster one of the allegations he's already talked about, or if that's a wholly separate allegation at that point. That's the problem that we have in this case, Your Honor, because we don't know. And I recognize that we are under plain error, but this court just about 6 months ago reversed in State v. Ricky Breeden, a very similar set of circumstances where the court went through closing argument and just went kind of line by line like we did in the briefs and said, well, the prosecutor never referred to the numbered counts in the indictment. There was never count 1 is this, count 2 is that, count 6 is that. That didn't happen. Then parts of the prosecutor's argument, specifically in this case, the sensation on all sides comment, doesn't appear to match with the timing or what that incident was tied to, whether that was tied to one of the February 11th, 2 different allegations on February 11th, or the other allegation, or again, something separate. It's not clear whether it's talking about JM or TM, and it's not clear whether it's even oral penetration or vaginal penetration. It's very unclear what that's even referencing. And then also, as in Breeden, here, the closing argument sort of makes it more confusing, and then we get nothing in the instructions from the trial court to help us out either. Again, I'll note this was back in 2009, but the trial court only told the jury, your verdict has to be unanimous. No one told the jury what that meant. No one told the jury that that meant it had to agree upon the same evidence, the same facts for each count in the indictment. This court, the Tennessee Supreme Court, have repeatedly said the state has to specify the facts, has to specify the evidence, has to specify the conduct, so that we know we can look back at that record with confidence and say for sure, this jury convicted Mr. Lee of these acts, this act in count 1, this act in count 2, and so on and so forth. I think it's clear from this record, it's clear from the disagreement in our briefs that we can't say for sure what this jury held. And that's the problem. That's the constitutional problem in this case. And for Mr. Lee, that should result in reversal on counts 1, 2, 6, and 7, the 4 that are related to JM. Again, we're not arguing the ones related to TM because I think that can be cleared up because there was only 1 count of rape of a child. And so here, again, I recognize we're on plain error. The Breeden case was also under plain error in this court reverse. And it is, with this being a constitutional issue, it is the state's burden to show that its constitutional error was harmless beyond a reasonable doubt. And I think this record is clear they cannot do that. Unless the court has further questions, I'll reserve for rebuttal.
Thank you. Excuse me, General.
Good morning, Your Honors. May it please the court. Austin Watkins appearing here on behalf of the state of Tennessee. In this case, the state's failure to make an election of offenses at the end of its proof does not rise to the level of plain error because it made an effective election during its closing argument. Therefore, Your Honors, the judgment should be affirmed. And I want to begin real quickly with answering your question, Judge Witt, about, which was regarding, I think, the timing of the election. And if I understood your correction right, part of the premise of that question was that the state made an election during opening statement. And I do want to be clear that it did not do that. The opening was very general about the nature of what was going to happen, but there wasn't any actual kind of assertion as to what the proof would show about each specific, penetration that the state was going to try to prove. So as far as timing goes, the only election was during closing argument. And the state did not make an election immediately around the time of the motion for judgment of acquittal, which was, at the end of the state's proof. So all that there would have been for the jury to go off of would have been the state's closing argument. And so
the opening of the state's closing argument, correct?
Oh, I'm sorry. Yes, there was the election during the opening of the closing argument. There was no election during opening statement, essentially kind of a narrowing of the indictment. I thought maybe that was part of the confusion. So I was trying to clear it up. I may have made it more confusing then.
Well, as I heard Judge Witt, that's exactly what he said, the opening of the closing argument.
I see. Okay, I understand. No problem. I understand that. So sorry to muddy the waters then. But to focus on what happened during the closing, the opening of the closing argument, the state, if you look at the transcript, there are two incidents that the prosecutor offers to the jury for each of the rape of a child charges as to the oldest daughter, who is the only victim where there are more than one count. And the incidents, I use that as maybe synonymously with encounter. And so the state describes the location where the sexual conduct was alleged to have occurred, which was once in the defendant's bed and then once in the victim's bed. And then the prosecutor says there was digital and penile penetration in the defendant's bed. And so that's the conduct that would support one charge, and then separately describes an instance of digital penetration in the victim's bed. So there are two incidents during closing argument that are discussed. There are three acts of penetration. What the parties very much disagree about is what the defendant says, what questions he's asked in the video as to whether or not there is a fourth incident or a fourth act of penetration that is referred to during closing argument. Your Honors, if you look at the video, starting at 28 minutes and 15 seconds through 28 minutes through 30 seconds, there's an exchange where after there had been some discussion about touching of the victim's mouth, the detective clearly pivots back to a prior line of questioning and refers to one of the elected offenses, the incident, the time when your wife was at the hospital. And at this point, there's really only been discussion of a digital touching. This is in the interview, digital touching and penile touching. And then the question involves the words vaginal cavity and it involves the words penis. And so when this discussion about sensation on all sides occurs, it almost only can be within the context of penile, vaginal penetration during the incident that was discussed at trial as being in the defendant's bed and was discussed in that interview as occurring in the defendant's bed while his wife was at the hospital with their son who had broken his arm. So the state wants to be very clear that there were only three acts of penetration that were discussed during closing argument, and two of those acts of penetration were very clearly in the closing argument and within the overall tenor of the proof were one encounter. So if there is a problem, Your Honors, it's because the state gave the jury the option of choosing digital penetration or penile penetration for that one incident in the defendant's bed. And so that...
What count would that be?
Well, Your Honor, presumably that would have been the first counts with regard to the oldest daughter, but as the appellant points out, the state never in its closing argument, tied the acts specifically to a particular charge. What it did was separate out the incidents and say, this time in the defendant's bed, that's a separate rape of a child act. And then this time in the victim's bed, that's a separate rape of a child act. And then
Shouldn't an effective election identify the count by number that activities being elected to?
it should, ideally, yes, Your Honor. It should. But under plain error, what the appellant has the burden of proving has to establish that his right to a unanimous jury verdict on this election question was ineffective. And so what we have here is, even though the state is not pegging them to a certain charge, it is very clearly limiting the proof from the witness stand and the proof from the defendant's recorded interview, which was basically what evidence there was for the jury, and is separating out the offenses. So it's not asking the jury just generally to pick from the grab bag theory that the case law has discussed, just pick whichever incidents about what you've heard about and convict on that. The state really was trying to say, in fact, did specifically say, focus on these two incidents. These are the two different things that we want you to remember. It didn't expressly say do not consider, but it did say these are the two things you need to focus your attention on, that time in his bed and that time in her bed. And that was what was before the jury at that point. And so although it was not a model of the best election that could have been made, it was an effective election under plain error review. And so that, if you look at the whole of all the proof that came in, there wasn't much other proof of penetration other than with regard to the oldest daughter for these two incidents. And so the state was, there wasn't a whole lot left for the jury to run with. Again, the state disagrees that the sensation on all sides comment was a separate offense. It was part of the state's understanding, was offering it as the defendant's own admission that the penile vaginal penetration in that incident in his bed, that was rape of a child. And that was what the timestamp from the video was mentioned in the transcript during the closing argument. I think it says 2850. And so the state is offering that not as a separate incident that the jury could have picked from, but as as more proof of that certain type of penetration for that one particular encounter is what it's doing. Your Honors, real briefly, I will mention that the state relied on State versus Knowles in its brief for the proposition that the prosecutor didn't have to specify which type of penetration that it was basing the rape of a child offense on for that one incident where there were two types of penetration, that incident in the defendant's bed. Upon further review of the appellant's brief and rereading of Knowles, it does appear that although there's some broad language in Knowles that would appear to support the idea that both of those could be offered, Knowles does not apply here. And so to pivot, what the appellant should have to show is that that under plain error review, that those two types of penetration, the digital penetration and the penile penetration for one encounter, were not a continuous, essentially a continuous act. And that would be under the Phillips factors that kind of have to do with whether or not double jeopardy would allow separate convictions or would require merger of those offenses. So I did want to go ahead and point that out, that the appellant's reply brief was effective on that, and pointing out that Knowles is not the best case to support the idea that there was no error with regard to giving the jury two types of penetration that the proof supported with regard to one specific encounter. Again, they're not separate incidents, but it is one encounter, that encounter that happened in the defendant's bed. So this is not the cleanest record, Your Honors. The state understands that. But when you really look at what the state was trying to do in its closing argument and what proof came in during the trial with regard to proof of penetration, there were 3 types of penetration in 2 incidents with regard to JM. And that was what the state was doing its hardest to get the jury to consider. So under plain error review, the appellant just can't show that, beyond a reasonable doubt, or I guess under the plain error standard that his right to unanimous jury verdict was adversely affected based on the state's election during closing argument. And so I'm happy to try to answer any questions and clear anything up to the extent I can. I hope I've been trying to be very clear and frank about the state's understanding of the state of the record here. But if there are no further questions, in the state would ask you under plain error to affirm this election. Thank you, Lawrence.
Thank you. Rebuttal.
Thank you, Your Honor. First, I want to say I appreciate the state's acknowledgement that Knowles and its limited, very specific circumstances do not apply here. And I think that the point that Counselor made about issues of double jeopardy that come up because of Knowles are exactly the point here. Whether we separate or don't separate the 2 different acts of penetration from February 11th creates questions of double jeopardy. It creates questions in this court's review of the sufficiency of the evidence. Which of those facts or acts did the jury base its verdicts on? That's the problem that we have here. Second thing I want to do is push back on this sensation on all sides. I understand the state's position as how it views the video, but respectfully, Your Honors, the way that the state is arguing it right now on appeal is not how the state argued it at trial. I broke down the cross-examination of Mr. Lee. This is from the record, volume 4, pages 215 to 29, is pages 19 to 20 in our principal brief. The state here today has said that the sensation on all sides referred to penile vaginal penetration in Mr. Lee's bed. That's what I understood the state to argue today. At trial, however, the prosecutor started with, on the night of the broken arm, that's the February 11th, you inserted your finger inside of her. That's digital penetration. This prosecutor then asked, on the night of the broken arm, you inserted your penis inside of her. That's the vaginal penetration. The prosecutor then asked about rubbing, putting fingers inside of her, rubbing your penis up against JM's vagina. The 5th one was an incident where she was sleeping on the couch. You rubbed your finger on her lips. 6th one, you put your penis on her mouth and rubbed across it. And here's the 7th one in cross-examination, Your Honors. The prosecutor said, quote, you put your penis to JM's lips and you felt sensation on all sides of your penis. That is oral penetration that the prosecutor was getting at. Whether that is consistent with the video or not, I think, again, is unclear. But certainly, I think it is too far to say that the state at trial connected the sensation on all sides comment to either the digital or penile allegations of penetration from February 11th. The way it came out of cross-examination, it was a separate incident. It was argued by the prosecutor as an incident of penile oral penetration. And then in closing argument, the prosecutor just played that clip from the video and said, you see, just like he said, sensation on all sides, he must have intruded. That's our definition for penetration. Again, not connecting it back to the night in his bed on February 11th. And I don't mean to imply that there's any misrepresentation. I just think it is so unclear here. And I just wanted to point out that the state's view of it on appeal is not how the state argued it at trial. Finally, Your Honors, the last point I'd like to make very briefly is regarding the comments by the prosecutor that was 2 counts. Again, there were actually 4 counts regarding JM, 2 for rape of a child, 2 for incest. I have been making the assumption all along that the jury picked 2 of the allegations of penetration for rape of a child and then used the same 2 for the incest charges. It's also equally possible that the jury picked 4 completely different acts of penetration for counts 1, 2, 6, and 7, because I've read the record multiple times. Nowhere can I find where the jury was told these 2 counts of rape of a child, they're the same acts that we want you to find for 6 and 7 for incest. Likewise, nowhere was the jury told differently that you have to find 4 acts of penetration. The prosecutor just kept saying that's 2 counts. There's actually 4. Again, Your Honors, I don't think that watching the video or reading the transcripts will clear it up. Certainly has not cleared it up for me. Don't think it's cleared it up for the state. Even under the plain error standard, we ask that you go back and review the analysis in Breeden. I think it's equally applicable here as to how the proof came out, what was inconsistent in closing arguments. And again, the state did not elect defenses. The question is whether what it did in closing argument effectively clarified the proof. I don't think you can say beyond a reasonable doubt that happened here. We ask this court to reverse those convictions regarding JM.
Very well. Thank you. Court appreciates the arguments presented today, and that concludes the arguments in this case. Thank you.
This court is now in recess until 1 p.m.